Good morning, everyone, and welcome to our webinar on the Disability Community Briefing, Defending Students with Disabilities in the Age of Trump. My name is Karma Quick-Panwala, and I am the Director of Children and Family Advocacy Services here at DREDF. It is a pleasure to be with all of you here today. I would like to begin with a brief overview as well of the agenda for today and also give you an introduction of some of our speakers. And on the slide in front of us is a photo of Jennifer Keelan, a young girl being assisted in climbing up the Capitol steps during the Capitol Crawl in 1990, taken by photographer Tom Olin. Our presenters today, myself with DREDF, Catherine Lehman, the incoming executive director with the Edley Center on Democracy and the Rule of Law, formerly the Assistant Secretary for Civil Rights with the Department of Education. Audrey Perino, who's the Senior Counsel for LGBTQI+ Equality, National Women's Law Center. Santiago Orozco, the Director of Organizing with the New Disabled South. Winston Berkman-Breen, who's the Legal Director at the Student Borrower Protection Center, and Julia Salowski, the co-president of the National Disabled Law Students Association. We also have Mary Goodwin Oquendo, the founder and president of the Goodwin Oquendo Law Firm and the adjunct professor at Fordham Law School. All of us today are looking forward to talking with you about our areas of expertise and our experience in these areas of law that are being directly affected. Our topics today that we will cover: what is the Department of Education and why it is so important? What has happened so far in the last 5 months, especially as it pertains to staff and cuts and funding? What students particularly are being targeted? Why are student loans a disability issue? What might happen next? A reminder that we still have rights and how we can make our voices heard. We will also reserve some time at the end for questions and answers. The Department of Education provides several core functions for students: the enforcement of civil rights, the enforcement of laws that help students with disabilities, and research and data collection. Catherine, I believe you're going to speak more to this.
Yes,
perfect. Thank you.
Can we go back
Okay.
one slide? Thanks.
Thanks all. Very much appreciate everyone coming together for this important conversation, and also very much appreciate DREDF for pulling this webinar together. So just to start with the Department of Education and what it does. Fundamentally, the United States Department of Education is a civil rights agency. Congress created it in 1979 to maximize equity for student learning. And Congress did create the Department of Education as its own standalone cabinet agency because Congress found that diffuse federal support among other existing cabinet agencies had not worked to ensure equity for students and for learning in schools across the United States. So the charge from Congress to the United States Department of Education includes activities like providing research and data about conditions of schooling and what kinds of education delivery works for students in our P-12 schools, as well as in institutions of higher education. And there's literally at the United States Department of Education something called What Works Clearinghouse. So that's a collection of materials that give instructors, give education communities at their elbow information about what works in schools. And these are research-based, supported ways to deliver equitable, fulsome, complete education opportunity to students in all schools in all of the United States. There's also data collection that is specific to the Office for Civil Rights, which I led, and I'll be happy to turn to that shortly, and also data collection and reporting about conditions of schooling year over year over year across the United States. And they include how many women are STEM majors in college and universities, how many students attend P12 schools, and what are differences among learning opportunities for kids in all kinds of schools in the country. The Department of Education also makes grants to support student learning in both P12 schools and colleges and universities. And I just want to be specific about the kinds of activities that those grants support, because they are broad and deep, and they matter a lot. There are 26 million students from low-income backgrounds who are served under Title I of the Elementary and Secondary Education Act, and they receive federal supports. Their schools receive federal supports to ensure that these students receive equal educational opportunity.
Catherine, we're going to take a quick break to unshare and fix our interpreter assignments.
Okay. Okay, I'm going to go back, but I'm hearing yes. I'll go back to describing the kinds of grant funding that the United States Department of Education supports. So there are 9.8 million students who are enrolled in rural schools, and they receive funding from the United States Department of Education to ensure their educational opportunity. Just one other category, there are lots more, but one other category to highlight that there are 6.6 million Pell Grant recipients for low-income students in colleges and universities in the United States, and they are receiving funding from the United States Department of Education to ensure their ability to access the education of their dreams. The Department of Education also administers federal student aid, and I know that we will hear more about that later today, so I will just note that student loans and administration of student loans is a large component of the work of the United States Department of Education. And specific to the disability community, the Department of Education enforces the Individuals with Disabilities Education Act. And to put a number to that enforcement work, there are nearly 7.5 million students with disabilities who are served by the IDEA. And then the Department of Education has a civil rights enforcement arm, and that's the office that I led. That's the Office for Civil Rights. I led that office during the Obama and the Biden presidencies, and it was the honor of my life. The work of the Office for Civil Rights is created by Congress when the Department of Education was created, and the office is charged to enforce non-discrimination based on disability, race, sex in schools, in every school that is federally funded every day for every student whose rights have been violated. So it is an enormous charge. And the Office for Civil Rights fulfills, or until January 20th, had fulfilled that charge by actively investigating complaints that come into the office, investigating information that the office has that civil rights have been violated in schools, also sharing resources and guidance about what the law is as written by Congress and as described in the regulations that the office enforces, and as courts have interpreted it, to explain to school communities so that somebody's mom, a student, an educator, a school board member, a college president would have information about what the law is and how the Office for Civil Rights enforces it. The Office for Civil Rights is also charged by Congress to create a specific data to collect specific data. It's the Civil Rights Data Collection, and it's data indicators collected since 1968 forward for every student in every school that is funded by the United States Department of Education in P12 schooling. And the kinds of data indicators include how many teachers there are who are certified in a particular school, how many students attend a school, absenteeism rates for teachers and for students, the numbers of students with disabilities who are taking advanced placement or high rigor courses in a particular school and in a school district, the numbers of students with disabilities who have been disciplined in a particular school or in a school district, and so many more. indicators about students' experience and the quantum of equity that is delivered in schools across the country. And I do just want to take a moment to say that there is a website for the civil rights data collection, and anyone can access the data that has been collected and published to date, and also can look at that data based on their school, their state, their school district, and compare to other schools to take a look at how those equity indicators shake out in different school communities as well. So I hope you all will take a look at that data and use it as I have done as well. Just to say that until January 20th, when the presidency changed, the Office for Civil Rights had been humming along. It has long been overburdened with a higher complaint volume than staff could effectively manage, but it was doing, I think, exceptionally well with the staffing that it had and the challenges that were coming in. Just to give some concretes, in the Biden presidency, the Office for Civil Rights resolved 7,574 more cases than during the prior Trump presidency, and fully 80% of the total number of cases resolved in all of the Obama presidency's 8 years, which is to say that the Office for Civil Rights was more efficient than it had ever been, and working to work through the cases well. And also it did that as against an enormous challenge. OCR during the Biden presidency had the second, the third, and the fourth highest case volume per year in history, ending the last fiscal year with nearly 23,000 complaints coming in that single year across all of the jurisdictional areas that the Office for Civil Rights enforces in, and only approximately 400 investigators to manage those cases. So there was a lot of work coming in, a lot of work going out, and still cases needing more and more investigation. And so the Office for Civil Rights would have benefited, would still benefit from more people to do that investigative work and give families and school communities answers about whether the law has been violated, and if so, how to correct those violations. So that brings us to where are we now? And what is happening now with the Department of Education? As we likely all know, President Trump campaigned with a plan to close the Department of Education and has issued an executive order directing the department to work on implementing that campaign promise. Separate and apart from that executive order and the president's promise, the Department of Education has laid off huge numbers of staff and curtailed activity that is within its congressional charge. And it's done that across many of the areas that I described earlier. So the impacts of those staff cuts affect the administration of federal student aid, affect the enforcement of the IDEA, affect civil rights enforcement in schools, affect the ability to deliver and administer grant funding, et cetera. These are very, very, very dangerous changes to the operation of the Department of Education and to the ability of those of us who are not working there to be able to expect that the department will fulfill its statutory charge. Just to say what I think we know, but to make it very clear, of course, closing a statutorily created cabinet agency requires an act of Congress rather than only a directive from the president. And so far, there's been litigation that has succeeded to date in securing a directive for the Department of Education to bring back the laid off employees and to continue its work as Congress has charged it to do. The Trump administration has appealed that order, so we will all see what follows as the litigation continues. In the meantime, specifically focusing on the office I led, the Office for Civil Rights, and the harms to the rights of people with disabilities, I want to talk about where we stand. The Office for Civil Rights in this administration has lost 7 of 12 regional offices. And that means that there are fewer than half the enforcement staff who had been in the Office for Civil Rights on January 19th, now in the offices. And news reports have made public that caseloads for the remaining staff are as high as 380 cases per investigative staff member. That is not a workable caseload. Staff cannot move through the required investigative tasks to investigate and resolve cases in an efficient way and to respond effectively to families with caseloads that are that high. There's also been recent reporting that has noted that the Office for Civil Rights resolved only 57, that's 57 cases that required change in the month of March, and 51 cases that required change in the month of April. The news reported, and I know this to be true, that during the Biden presidency, the Office for Civil Rights typically resolved 200 such cases in a given month. So the substantive resolutions delivering change for communities are roughly a quarter of what they should be in this administration. And that's also quite dangerous for civil rights in our schools and for our kids and students' rights that they're trying to learn. Just to say also, in March of this year, the Office for Civil Rights dismissed fully 91% of the cases that it resolved. That means that only 9% of the cases that it resolved were cases that had a substantive resolution of any type. The other 91% of the cases coming out of the Office for Civil Rights were just a decision not to investigate. So, that's quite damaging, and it doesn't augur well for our ability to secure rights now from the federal government. I want to talk specifically about what that means for the disability community and for disability rights. The Office for Civil Rights in this administration has issued press release after press release after press release about case openings and about guidance published, but it really has not said all that much about disability at all. Last month, it issued its first press release related to disability. And there it noted that it had opened an investigation of whether white students with disabilities were discriminated against when a district allegedly favored providing services to students of color with disabilities. And that would, of course, be discriminatory, and it is within the Office for Civil Rights jurisdiction to investigate. But it's notable, though, that this set of allegations is the only time that the Office for Civil Rights has used its voice related to disability in nearly 5 months of this Trump administration. Historically, disability claims have been 50 to 60% of the work coming in to the Office for Civil Rights. And those complaints have ranged from topics such as whether students with disabilities have been discriminatorily restrained or secluded at school, or students with disabilities do not receive timely evaluations or the services and accommodations required under IEP or Section 504 plans, or students with disabilities are segregated from their non-disabled peers, or students with disabilities experience discriminatory discipline in school, or students with disabilities who are English learners receive the services that they need in languages that they and their families don't understand, or that students with disabilities are over or under identified as students with disabilities. Or, for example, this is my last example, but these are the kind of things that come in, but students with disabilities lack access to the full range of coursework available to their non-disabled peers. I know claims of this type are still pending in the Office for Civil Rights because we were working to resolve those cases before I left in January. So it is gutting to me to see the Office for Civil Rights not announcing resolutions of the very many cases addressing the rights of students with disabilities to equal access to education. In this administration, the Office for Civil Rights has repeatedly communicated its preference for civil rights protections for certain groups to the exclusion of others. This preference, so far, notably has not included students with disabilities as a class. The administration has spoken over and over again to its disdain for inclusion of transgender and non-binary students and students of color in particular. It's, for example, issued an executive order threatening criminal prosecution of educators who even refer to students as non-binary, whether or not the students' parents and the students have informed the schools of the correct identification for the students. And it is claimed to require certification from states and school districts that they will conform to an understanding of non-discrimination based on race and color that no court has adopted. Of course, that expression of disdain negatively impacts the disability community, whose members include students of color and trans and non-binary students. And the administration's relative silence regarding the rights of students with disabilities itself excludes and harms students with disabilities, given the high volume of discrimination still persisting based on disability itself. There is one comparatively small upside to the silence, though. The administration has not rescinded disability-specific guidance that families and advocates can still use. Just as one example, we issued in July 2022 guidance regarding the civil rights protections related to discipline of students with disabilities, and that is still on the Office for Civil Rights website. The key take-home in that guidance, and in the law the guidance describes, is that students with disabilities cannot be disciplined for disability-based behavior. Cannot. And the guidance describes the kinds of interventions and supports mandated under federal civil rights law, specifically Section 504 of the Rehabilitation Act, related to discipline of students with disabilities. So I hope you all will use and share that guidance among many others that are still available, covering topics such as web accessibility, the rights of English learners with disabilities, and specific conditions ranging from asthma to epilepsy to diabetes to food allergies to depression or bipolar disorder, anxiety, or eating disorders. So I hope that you will find, use, and advocate for students with those disabilities and using that guidance still to support the disability community. I'm going to make one last flag, and then I'm going to stop talking at you and look forward to the rest of the webinar. But there are lots of pending cases in the Office for Civil Rights now. That's generally been true, and it is especially so now when this administration is mostly dismissing cases that have come in, opening a very small number of new complaints, and not spending its staff resources on resolving the cases that have been pending. Our kids need our federal government to do more, and their rights depend on it. So I'll stop there. Thank you.
Thanks, Catherine. We're going to hear from Mary now about how these changes are affecting people with disabilities in the real world.
Yes, thank you so much, Karma, and thank you, Catherine. A significant percentage of my practice involves helping students in post-secondary and professional settings. So college students, graduate students, law school, medical school students who need accommodations, who've experienced disability-based discrimination, retaliation, harassment, etc. And I'm a huge fan of alternate dispute resolution. So for many years, I have either encouraged clients to file on their own, or I've guided them through the process of filing complaints with OCR. And that's because I found, prior to now, that OCR was really, really effective at addressing these issues in a timely fashion, right? Primarily through mediation that occurred before a case was opened or after a case was opened. I thought it was a good opportunity for people to come to the table and find practical solutions that would allow students with disabilities to resume their educations, move forward in their careers, and just be treated with the respect that they deserve. Now, I will say that presently, I have a number of clients, and I know of other people who are not clients, whose OCR cases have completely, essentially disappeared. I had, for my clients, I had some cases that were in the process of being resolved through mediation, right? And because of the office closures, and then also because of the workload that Catherine described, I think she said it was 300 and something cases per investigator, there's literally nothing happening. Meanwhile, people are getting bad grades because they don't have their accommodations. They're facing disciplinary actions, etc., because they're unable to do well. So it's a very, very difficult situation, and people are addressing this, and I'll talk about this in greater detail when I speak toward the end of the program. People are addressing this by engaging attorneys, looking to state and local agencies to file complaints, etc. So I just wanted to give my 2 cents on that, because it's already expensive. It's expensive to be poor. It's expensive to have a disability, right? People are racking up these student loans, and there are so many consequences resulting from that my fellow panelists will be able to speak on. Thank you.
Thank you very much, Mary. I'd like to pass this off to Autumn Perino to speak on the civil rights of trans and non-binary students in schools today.
Hello, thank you for having me. My name is Auden. I'm an attorney at the National Women's Law Center, where we have worked for over 50 years towards the full enforcement of Title IX and other important civil rights laws. We have supported the growing consensus in the majority of courts and also the civil rights community to understand that Title IX's prohibition on sex discrimination and sex-based harassment in schools has always protected queer, trans, and non-binary youth. It's also, there's an important ongoing fight to recognize that some trans and non-binary youth who have diagnoses of gender dysphoria are entitled to accommodations in school under specific laws such as the ADA and the Rehabilitation Act. If you take away one thing from my portion of this presentation, it should be to understand that schools must not back down from their legal and professional obligations to support and protect all of their students. And that includes students who are trans, non-binary, and intersex. Regardless of who is in the White House, all youth, including trans students, deserve to learn and to grow up as their truest and best selves. And that means being included in every part of school. If we can go to the next slide. It's very important that we are holding space to discuss the overlapping education rights and needs of LGBTQI youth and disabled youth. There is a large Venn diagram for these communities. And also the topics, the movements for disability justice, gender justice, and queer and trans liberation are intertwined. I'm going to focus on the rights of trans students specifically, given the unprecedented attacks against their rights, and also the reality that 30% of trans and non-binary students self-identify as having a diagnosed disability. This overrepresentation is a product first of the reality that transphobia is a disabling force. And it's also important to understand our opponents are using a shared playbook, seeking to dehumanize and to strip autonomy from trans and non-binary people as well as disabled people, using some of the same tactics. We're going to talk a little bit more about school sports in just a moment, but I'd like to define this term here. It says anti-trans school sports bans rely on sex testing. Sex testing here means a range of unscientific and traumatizing practices that can range from collecting students' genetic information or medical records all the way to invasive physical examinations of students' bodies. Looking at the history of sports in the US and around the world, we know that body policing and gender policing in sports causes the most harm to Black and brown women and girls. And we will also discuss a White House promulgated order that is trying to enforce a narrow and unscientific definition of sex. Next slide, please. I'm going to review 3 actions from the White House, but the summary, the short version is that the Trump administration has rolled out a series of devastating attacks against core institutions, including safe and inclusive public schools. This is not happening in a vacuum. These attacks are taking place against the background of an extremist hate movement that has spent years pouring tens of millions of dollars into manufacturing panic over the fact that trans and non-binary students exist and attend school like every other young person. The movement to create this moral panic and distort our media, our laws, and our culture includes many of the same people who have been attacking our rights to birth control and to abortion healthcare, which reveals the true goal is not about supporting or protecting any student, but instead growing power to police our bodies, how we express our genders, and how we form our close relationships. I would like to highlight this second tactic the most. The Trump administration has been relying on us to be misinformed, confused, and most of all, afraid. They are relying on fear to force many schools to break the law and begin specifically singling out their trans, non-binary, and intersex students for bullying by the same adults who are supposed to protect them and their rights to learn. Next slide, please. So you will see here, this slide lists 3 executive orders from the beginning of 2025. The first order listed at the bottom directed every federal agency to use a baseless and harmful definition of sex that is specifically designed to exclude trans, non-binary, and intersex people from recognition by our government, and to make it harder for us to navigate everyday life. These later orders have been encouraging schools to distort teaching about race and gender in our country's history in ways that will harm all students who are entitled to know the truth, even when the truth can be difficult, but especially causes harm by erasing and othering trans, non-binary, and intersex students. And then, of course, we have a February order that pressures schools and athletic associations to categorically ban every trans girl and woman from participating in sports alongside her peers. This is a lawless order that is an abuse of government power, and it is rooted in sexist gender stereotypes, saying that essentially there is no such thing as trans girls and trans women, when this is very far from true. And these students do have civil rights protections at school that no executive order can take away. The administration has lied by calling its attempts to bully trans youth protection for girls and women, when in reality, the existence of trans students is not a threat to anyone. And there are very clear stories showing that when we begin policing the genders of students, all students suffer harm, and girls and women drop out of school sports because of the sex stereotypes that are baked into these kinds of policies. Next slide, please. So this, I'm not going to read every word on this slide, but if we zoom into the issue of school sports, I'd like folks to remember that from 2008 to 2018, we saw trans students playing sports openly under supportive, inclusive statewide policies with zero problems. The first attempts to kick trans students out of school sports, which began in a court case in Connecticut and a state law in Idaho, were bankrolled by a hate group called ADF and other far-right extremists who were afraid of the coalition that was forming for civil rights in the wake of the marriage equality decision.
Auden, you have about 1 more minute.
I got you. The other thing I'd like to note is that federal data from the Centers for Disease Control and Prevention show that in jurisdictions that include and support trans student athletes, we see more girls and women playing sports overall, not less. And then if we can move on to the final slide, I'd like to just recall the remarks from my fellow panelists about how the Department of Education has been limited in completing its mission, and how specifically the Office for Civil Rights has been distorted in ways that leave disabled students who are experiencing discrimination out in the cold without the support that they need. Whereas resources are being devoted to intimidate schools who include and support their LGBTQI students, as they are legally and ethically required to do. It was very harmful in January for the Department of Education to dismiss 2 complaints that my team worked on in a way that specifically called censorship and book banning a hoax. It is not a hoax. There are real efforts to resegregate schools and to teach a whitewashed and queer-washed version of history. And the other policies named here are additional efforts by DOJ and ED to intimidate schools and to directly bully trans and non-binary youth. On this next slide, you'll also see that other agencies have been directed to do similar actions. There have been multiple investigations against Maine because they support their trans youth, and Maine actually had to go to court to fight to restore funding for school lunches and similar child nutrition programs that was under threat simply because they include and support LGBTQI youth. Thank you so much.
Thank you, Auden. I'd like to turn this on to Winston to talk about student loans and assistance.
Great. Thank you so much, everyone, for putting this on and for joining today. My name is Winston Berkman-Breen with the Student Borrower Protection Center. We all have the impossible task of trying to cover a huge amount of information in a short time. So please bear with me as I talk about what's going on with student loans generally, because it was already an incredibly confusing and changing system. And then with respect to what's going on in DC right now. So the areas I'm going to touch on the most are public service loan forgiveness and income-driven repayment plans, though I do, of course, want to note the existence and importance of total and permanent disability discharge, which provides that if a federal student loan borrower with a, quote, total and permanent disability, which is described and is established through a couple of different means, they can have their federal student loan debts eliminated, basically discharged. This has never been a perfect system, but again, with recent staff cuts as recently as March, although that's being litigated, and just a policy ideology that is pretty anti-borrower and anti-low-income person, things are getting worse at the Department of Education. So I think this is relevant both in terms of the work to serve communities of people living with disabilities, but also for those service providers who may have debt themselves. So if we want to go to the next slide, please. I'm going to start by talking about public service loan forgiveness. For those who aren't familiar, it's a bipartisan congressionally created program that says that if you work in public service for 10 years, government or nonprofits, and you make payments pursuant to particular payment plans during that time, you can get your debt canceled after that. This was a historically and sort of comically dysfunctional program for the first 15 years or so of its existence. The Biden administration took the opportunity from the federal student loan payment pause during COVID to fix this system. And it went from having canceled 1,500 people's debts in 2019 to over 1 million by the end of the Biden administration last year. And they did that not through acts of Congress, but by making the existing congressional program work better. They also incorporated something new, which we're really seeing for the first time now, called a buyback option, which says that if you had the right job, but maybe made a payment or an ineligible payment at some point in the past, you can today make a payment that recuperates that past time. So nothing is really final on that front. And that's just an example of the flexibility there. And I'll, in a couple of slides, talk about sort of what's the state of PSLF today, but wanted to note what it is in the history of it. And if we go to the next slide, I'll do the same for income-driven repayment. So IDR, or income-driven repayment, is one of your monthly payment options for federal student loans that says your payment will be based on how much you make, not how much you owe. So if you are a lower income person, you can have a low or even $0 payment, and that counts as a full monthly payment.
Winston, Winston, this
yes.
is Claudia. We've gotten, I super appreciate you trying to stay us on time, but I've gotten a request for you to slow down for the captioners.
All right, I can slow down, but I can't promise to stay on time then. So everyone's going to bear with me. So just to recap, public service loan forgiveness, right job, right payment plans, 10 years, you can get your debt canceled. It wasn't working. It's working much better for Biden, and we'll talk in a couple of slides about how it's working under the current administration. Income-driven repayment plans, IDR, are a payment plan, and what they do is they offer payments based on your income, not on the amount you owe. So you could owe $500,000, but if you're a lower income person, you can get a lower or even $0 monthly payment. And this is a real life raft for a lot of folks. It doesn't ensure or guarantee affordability, but it is usually more affordable than their regular standard payments. IDR plans also offer their own form of debt cancellation and forgiveness, the idea being that if you are on a low payment, as the plan provides, you're perhaps never chipping away at the amount you owe, so you could be stuck in a debt trap. So Congress provided that after a certain period of time, generally 20 or 25 years, being on IDR, you can get your debt that remains canceled. So that's a payment plan that has a cancellation provision built in. This also wasn't working so well, and the Biden administration has also taken steps to fix it, and 1.4 million people became debt-free through this. In 2019, that was 32 people, right? Huge difference. Biden also introduced a new form of IDR plan called the SAVE plan. And if we go to the next slide, I'll talk about the SAVE plan because many folks may be on it or have heard about it. So the SAVE plan is the newest IDR plan, also the most affordable. It was introduced in 2023. And then a couple of months later, a crew of conservative Republican-led states sued to block it. And for about a year, it's been caught up in litigation. Most recently in February, an appeals court, the Eighth Circuit, upheld an injunction against offering the SAVE plan while the case is proceeding. So there hasn't been a determination on the merits of it, but while the case is being reviewed, it can't be offered. So about 8 million people who were in SAVE, because it was the most affordable, have been put in forbearance, sort of a state of limbo where they don't have to make payments, but they're also not progressing towards being debt-free one way or another. Now, related to the SAVE plan litigation, the Department of Education actually took all IDR plans offline. You could not apply to or have your application reviewed for an IDR plan if you were not already in it in February, and only restored that in March and early April after a teachers union represented by my organization sued in federal court in DC. That litigation is ongoing because they still haven't gotten back up to speed in terms of processing, and so people are still practically unable to access IDR. If you go to the next slide, I'll just very briefly say where we are on both of these really critical programs that are both about affordability and being debt-free. So I mentioned buyback as an interesting opportunity to make PSLF work for you, but there's a huge backlog there too, about 50,000 applications. And we also are looking out to protect public service loan forgiveness because the Trump administration issued an executive order in March saying that they were going to use PSLF as a tool to target and punish groups that they disagree with, essentially saying that they would make ineligible certain groups that do immigration work or trans rights work or anything the administration disagrees with. The Department of Education will work to implement that this summer, and we're we and colleagues are prepared to sue as soon as they start to take those steps and the lawsuit is ripe to be heard. So keep an eye out on that. But as of today, PSLF, you should be able to get your debts canceled if you qualify. Similarly, with the IDR plans, we know from litigation there are about 2 million applications waiting to be reviewed and a backlog. And there are rulemakings that will go on to potentially change the plans. And at the same time, Congress, through the budget process that's happening right now, is threatening to remove the IDR plans and replace them with a less affordable alternative payment. So there's lots of advocacy going on there. But again, unfortunately, we're seeing a pretty callous Republican-led Congress who's taking away rights and making life less affordable for people. And then you layer on top of that there's simply no staff left at the administration, at the Department of Education, to help people when they have problems. So this is all still sort of ongoing, and I hate to leave on that sad note, but it is sort of stay tuned on the accessibility of these programs going forward, which are really core affordability, debt-free tools for all borrowers, but especially for those serving certain communities and members of the community living with disability.
Thank you very much, Winston, for getting through so much information so quickly. This is Karma Cook-Penwala with JEDF, and I'd like to move to the next slide, please. So with the Department of Education, what might happen next? Right now, the current administration wants to move different parts of the Education Department to the Department of Health and Human Services. We don't know where in HHS they want to move those parts, or what will happen, or which parts of HHS might administer them. We do know that the department wants to move student aid to the Small Business Administration, and that they are eliminating Head Start. In the current budget reconciliation that is making its way through Congress, we know that school choice through a federal voucher tax credit is on deck, as well as increased discrimination against disabled students, because many of those private schools or religious schools are not required to provide accommodations or special education services to students with disabilities. And what's more, through the reduction of the Medicaid services and funding in the budget reconciliation bill, we know that there will be decreased funding for special education health services and counselors that would often be covered under Medicaid. For the fiscal year 2026 proposed ED budget that was released earlier this week, we know that there's a 15% cut overall in funding to special education and to other agencies and organizations receiving federal funding that would affect students with disabilities. We also know that there are $4.5 billion in proposed cuts to K-12 programs, including the McKinney-Vento Act for Homeless Youth, and huge cuts to federal work-study programs. The Pell Grants will be cut from roughly $7,300 to $5,700. Next slide, please. And litigators are fighting back. There were 2 cases, each filed against the administration regarding the cuts and closures of the Office for Civil Rights in the Department of Education. One of those cases was filed by the National Center for Youth Law and the Council of Parent Attorneys and Advocates. This case was filed to ask for and be a preliminary injunction or a stop to be granted in their favor to make sure that the administration was no longer cutting positions or closing offices. Unfortunately, that case, which was filed in Washington, D.C. in the federal district court there, the request for preliminary injunction was denied. However, there was a separate but similar case brought in the first district, in the District of Massachusetts in Boston, and that was brought by 21 state attorneys, as well as a number of unions and organizations. That case was granted a preliminary injunction to stop the dismissal of federal workers and to stop the closure of OCR offices across the country. And yesterday, the First Circuit Court of Appeals in Boston upheld that preliminary injunction and denied the Trump administration's request for a stay, meaning to stop the preliminary injunction and allow them to continue with those cuts. So we do want to make sure that people are aware that the litigation is ongoing, that we are starting to see some turn in favor of students and families and people with disabilities in schools across the country. Next slide, please. With that, I want to turn this over to our next speakers, who I believe is Santiago.
Much, y'all. Hi, everyone. My name is Santiago Orozco. I use he, him, they, them pronouns, and I am the Director of Organizing at New Disabled South. Today, I am talking about the impact of a lot of federal policy that's moving and how it's impacting students of immigrant families. So first, want to highlight a couple of the executive orders that we have seen come out that are impacting folks. First, there was on January 20th, an executive order stating that undocumented immigrants must register for a national database. And then on February 12th, to the present, we have seen sorry if y'all can hear my dogs in the background, they're being a little loud right now. Going back to what I was saying, we have seen a media campaign coming from the federal government that has been targeting undocumented immigrants. The message of this campaign has very much been focused on self-deportation and or implicating that folks would face fines or imprisonment for staying in the United States. On March 12th of this year, we saw that Department of Homeland Security, or DHS, set out a process for registering. So they officially came out with what the steps were for registering for the database that became effective on April 11th. And I'm reading this quote from the National Immigration Law Center, which says, coming forward to register will be extremely dangerous for most undocumented community members. It could lead to detention, deportation, and possibly criminal prosecution. And so these are changes in federal policy that are increasingly targeting immigrant families, but the impact isn't only going to be felt on immigrant families. And if we can go to the next slide, there's one more executive order that I need to touch on. Next slide, please. Thank you. So there was also another executive order issued on the 24th of January this year. Sorry, directive that was issued by the Department of Homeland Security, which rescinded guidance that was, rescinded decade-old guidance regarding ICE enforcement in sensitive areas. And so this would be places like churches and schools and hospitals. This is a quote from the Secretary of I believe this is an undersecretary, which basically says criminals will no longer be able to hide in America's schools and churches for void arrests. That was Benjamin Huffman. And so that is the intention. That is the goal of the administration, to enforce immigration policy and their directives in these sensitive places. And so this is why we say that this is not only going to impact folks who are undocumented, but also likely a lot of children who come from mixed status families. And if we can go to the next slide, we wanted to highlight some specific research that the Kaiser Family Foundation has put out in terms of what the physical and emotional and mental impact of these policies is going to be on for the millions of children in immigrant families. And in their research, they highlighted that this is going to impact 1 in 4 children nationwide. And so some of these impacts are going to be increased fear and stress affecting their daily lives, problems sleeping and eating, headaches and stomach aches, mental health conditions like depression and anxiety, decreased performance in school, reluctance to access programs and services, and long-term health consequences. And so, sorry, is my audio not coming through correctly? Oh, this was a couple minutes ago.
It's a little unclear, but just keep going, Santiago.
Heard. And so I'll land the plane with this, but the point that I wanted to highlight as part of this conversation is that there are a lot of pieces of federal policy that are moving and targeting undocumented folks, both the executive orders and directives that were explicitly named, but also we're seeing multiple pieces of legislation get proposed that add on penalties for folks who are undocumented. And so this is just to highlight that there's a lot of policy that's targeting undocumented folks, and this is creating an environment where families may choose to not apply for certain social benefit programs, social safety net programs, and that'll directly access the healthcare and benefits that students in these mixed status families are going to be able to access. But also, there's a very real lack of access to services and healthcare in detention facilities. We have seen instances where US citizen children have been detained alongside their undocumented parents. And so wanting to highlight that even if a student has citizenship themselves, the impact of these policies can still impact them, both directly accessing services, but also the way that their family may participate in federal and state programs. And I will turn it over. I believe Julia is going after me.
Julia, we welcome you to speak on this next slide and to give your thoughts. Thank you.
Hi, everyone. My name is Julia Solafsky. I use they, them pronouns. I have brown, curly-ish, frizzy hair. I'm a white person, and I have brown eyes and dark eyebrows. I'm an autistic, non-binary professional and activist. I was recently the co-president of external affairs with the National Disabled Law Students Association, NDOLSA. We have gone through a transition period, so now there will be a new president taking over soon. And I've also been doing education advocacy for about 5 years now, both in higher education, K through 12, in both Baltimore, Maryland, and Central Virginia. Some relevant background information about me that I think is really relevant to this topic is that I was diagnosed autistic at the age of 25, but I've been autistic my whole life. I've been a heavy masker. I was funneled through education programs for gifted children that denied me receiving resources that I needed to succeed. I have immigrant parents. We did not have access to great health insurance. We did not have access to considering an autism diagnosis. And so I spent my whole life thinking that something was wrong with me, when in reality, I was just autistic and it was actually perfectly fine. But the issue is right now, this Trump administration has decided to push back on some of the things that we have progressed with over time. The Department of Education has for a long time been a safety net for some of my rights and my people that I serve rights in education. And yes, that net has always had a lot of holes. I definitely fell through some of them. But rather than mend these holes and patch the net, the Trump administration has determined that my identity in life is not worthy of protections under the law and slashed the net open. Now, of course, the safety net from the Department of Education is also contingent on people feeling safe enough to even get a diagnosis or have the resources and money, or even have the right to identify properly, the privilege to have a certain identity to be considered for a diagnosis. For example, we know that Black and brown students are more likely to receive a different type of behavioral diagnosis rather than be seen as autistic or have another developmental disability. They might be seen as disruptive rather than being accommodated for the disability that they may actually have. The current administration's attack on non-binary and autistic students moves beyond the law and affects our functioning and existence in education and daily life. So I decided to put this quote up by Robert F. Kennedy Jr., and I think many of you have seen it before, but the reason I want to talk about it is because it not only echoes this current administration's issues, but it also echoes what we have been trying to fight against for, I would say, a few decades now, especially in the early 2000s. He said, "Autism destroys families, and more importantly, it destroys our greatest resource, which is our children. And these are kids who will never pay taxes, they'll never hold a job, they'll never play baseball, they'll never write a poem, they'll never go on a date, many of them will never use a toilet assisted." And so for right off the bat, RFK is spewing a rhetoric where, for one, he believes that it is negative to even have to have assistance to use a toilet. And that isn't the case. It doesn't matter. It shouldn't matter what assistance you need. But he's also spewing this rhetoric that autism itself is a destructive force, when in reality, it is ableism, transphobia. These are the destructive forces against us. I pay taxes, and I don't even get the relief on taxes that I wish I did have. So statistically, this type of rhetoric, it's a personal attack. So 66% of autistic adults have contemplated suicide and 33% have actually attempted. This is according to a study by Nottingham University. Many of the pressures on autistic adults come from the society's inability to accept and provide systemic resources for us to thrive. And I'm not saying not merely survive, but actually thrive. I should be able to have the resources I need to be able to take a break, to be my authentic self, and not suffer from autistic burnout. I work directly with students advocating for their disability accommodations in higher education, and this administrative attack raises concerns for me about whether or not someone is even safe enough to get a diagnosis. A lot of the rights that the Department of Education provides for us are contingent on having access to healthcare and contingent on providing medical documentation that I need an accommodation. But those things prior to this administration were already affected by intersectional identities. For example, non-binary and trans people have to consider the following when determining whether to even fight for our rights, whether to even file the OCR complaint. Perhaps I am a Black or brown person. How will fighting for my rights be perceived on the basis of my skin, accents, gender, and identity? Do I have the money to get a proper attorney? Most attorneys in education do not take a contingency-based pay fee, which is where you only pay if you win. Access to healthcare. Am I able to get the proper documentation for a diagnosis? Most healthcare providers do not provide a diagnosis for autistic adults. So people in higher education, and especially since women and Black people were very little diagnosed with autism in the early 2000s, we have to get diagnosed now as adults. What about our comfort level or our ability to navigate procedures that are difficult? And the reason I bring this up is because I think it's important to talk about what was already going wrong and how this system, how the Trump administration is backpedaling a lot of progress that has been done with language, community building, and just mere discussions. So I advocate a lot for others and experience, and I have a lot of experience in doing so. But I want to talk about my personal advocacy. When it comes to my own rights as an autistic non-binary person, I have a really hard time even writing letters for my appeals or reconsideration. And that's because it is personal. It is personal that this administration views me as a destruction, as something that destroys children, as something that is a burden on the system, when I believe that we are all a benefit to the system. When I advocate for other students, it's a little bit more separate, and I'm only able to advocate for so many. But I've seen many students who aren't able to even use their rights prior to this administration because of the heavy burnout and the toll that ableism places on us. In addition, it was already difficult to ascertain the rights of autistic and non-binary people in the past because we weren't necessarily recognized under the law. I think Auden spoke about this earlier, but essentially as a non-binary person, the language that is used in the law, I like to call this middle identities. They don't necessarily recognize the nuances of somebody who masks a lot, who's autistic, or a non-binary person who maybe not identify necessarily as a transitioning person. And accommodations include non-binary people who might need accommodations for gender dysphoria, which was recognized by the Fourth Circuit and then adopted by the Department of Education and Regulations. We also have the impacts of the Autism Registry. And although that the Department of Health and Human Services rolled back on this, for some of you that may not know about this, they wanted to create a registry which tracked how many people were autistic, and it was going to have negative impacts. When this came out, a lot of people started to fear getting their children diagnosis. And these are people who already were even considering the access to getting that diagnosis, who are now considering not doing that for the fear that their children are going to be funneled through a registry program or for whatever else could happen from there.
Julia, you're at time, so if you could wrap up.
Oh yeah, I can wrap up. So my point is essentially this type of fear, even though it's not happening, it is continuing. It is causing people to not seek their rights, to not advocate for their rights. And rather than expanding the rights that we have, we are now under a pressure to be able to consider our survival and safety first, rather than even advocating for ourselves. And thank you so much. I'll pass it on to the next person.
Thank you so much, Julia. I want to turn this over to Mary Goodwin Oquendo to talk about the fact that we still do have rights and we can enforce them.
Thank you so much. I just want to piggyback off of something that Julia said, that the current administration is going to great lengths, it seems, to make people with disabilities feel as if they're a burden or we're a burden. And I just want to remind everyone that, people with disabilities enrich every space that they're in, whether that's a school, whether it's a place of employment, whether it's an event. And that's just something that everyone should keep in mind. Now, a few takeaways. These executive orders that we've been seeing, they're not laws. These letters from the agency secretaries like HHS, DOE, DOJ, those are not laws. The laws are the statutes. So let's look at what's in our toolbox, right? So if new federal legislation is proposed, throughout that legislative process, there will be a number of opportunities for members of the community to share their, pardon me, to share their concerns, describe their experiences, organize and advocate. That's just something that's built into our legislative process. That takes time. That isn't something that they can do overnight. The laws that we do have, like the Americans with Disabilities Act, the IDEA, Section 504 of the Rehabilitation Act, those are laws that more or less were passed with bipartisan support previously. So that's something else to keep in mind. Also, the language of the statutes themselves have some safeguards. So we don't look to the president, we don't look to the heads of these agencies to define, for example, disability. Each of these statutes that I just named, they have their own definition of disability, their own definition of what's a covered entity, also rules of construction. There are a number of additional safeguards there, right? So I think it was, I'm forgetting specifically who said it, but the statutes also say which agencies are responsible for issuing enforcement regulations. So to the extent that the president has decided that he wants to move what the Department of Education does to HHS, you can't just say it. It's something that has to be passed. The laws also, specifically the IDEA, has a much more detail that I think should be reassuring to people, right? So the Office for Special Education and Rehabilitative Services, which is responsible for providing special education and vocational rehab services to schools, families, districts, and also states, that's built into the language of the law. Additionally, the IDEA says that, for example, the Department of Education secretary can't issue guidance, informal guidance that conflicts with the law. So again, that's another safeguard here. With regard to the Americans with Disabilities Act, the EEOC, for example, is responsible for issuing regulations dealing with not just employment, but the definition of disability. Department of Justice is responsible for Title II and Title III, which is state and local governments and places of public accommodations like schools and things that my clients have to deal with on a regular basis. So look to the law to understand what the administration and their proponents, what they can and can't do. But when you're looking at their the executive orders and the letters that they're releasing, look at it as a clue as to what we must do in organizing. Don't let the fear take you over and paralyze you, because that's a lot of what I've been seeing. Also, I think it's important to know that there are a lot of protections at the state level. For example, New York has a state human rights law. New York City has a human rights law, California. So also check your state so that you can avail yourself of those protections as well. As I mentioned previously, OCR unfortunately isn't really reliable at this time. So now I see people looking more toward the state enforcement agencies like the Human Rights Commission, Division of Human Rights in New York State, and then the California Civil Rights Department as well. And let's see, there are a number of other things. I know we're a bit behind, so I'm going to try to to speed up, but keep asserting your rights. Keep asking for accommodations in school. Keep calling out discrimination and retaliation. If you can't do it at the federal level, you can do it at the state level. Still, if you want to file a complaint with OCR, do it, because that is your right. Just know that, practically speaking, it may take some time for them to act on it. But they do have a statutory duty to investigate your complaint. We're seeing how that will play out, but they do have that. Do participate in the IEP process, file a due process complaint if needed. Also, you can file a case in state or federal court. And for all of these things that I've just described, you can absolutely consult an attorney to understand your rights. Consulting an attorney doesn't necessarily mean heading into court. I know myself, for example, I help people behind the scenes all the time so that they go into these adversarial situations, understanding what's at stake, what powers they have, how things can potentially play out. And that's pretty much it. Don't forget that we still have power, and don't fall for the trap of acting out of emotion and then not being rational about things. So that's all.
Thank you so much, Mary. That was a great recap. I do want to, this is Karma from DREDF. I do want to make sure all of us remember this is still the time to be contacting our elected representatives. And it's still time to be using any of those apps, making 5 calls, knowing where your senators and representative offices are. If you're able to stop by those offices, please do. Tell them to defend students and to defend the Department of Education, to defend students' rights and access to all of the things that students need to be able to thrive at school, to get their education. We have some tools listed on this website, and the slides will be shared. The recording will be posted on DREDF's website afterwards to address some of the questions in the chat. So please make sure you find these links and use them as you continue to use your voice and your own ability to advocate. And tell your representatives, and especially your senators now, to defend Medicaid against the billions of dollars in cuts. This reconciliation bill is currently before the Senate, and so our attention has turned to our senators to defend Medicaid and to make sure that we keep it intact, as well as Social Security and Medicare. Thank you, everyone. I'm going to turn this over now for questions, and we will try to address those. Next slide. Oh, I'm sorry. Claudia's coming up with a couple of updates and some information. Claudia, I'll let you take this away.
Sure. Hi, everyone. This is Claudia Center with DREDF. She, her, hers, white woman with brown hair, over 50 with glasses. And I think it's really important that we all try to make our voices heard and to, if we are able, join protests. One thing that we have coming up is the ADA anniversary in July, and that means there are often anniversary events, and we urge people to join existing events or organize your own events and use the occasion to express yourselves against what this administration is doing to our communities. To people with disabilities and to all regular people who are trying to live and thrive in our communities. There is a July 21, 2025 rally sponsored by the National Council on Independent Living in DC. There's a June 16, 2025 rally in Sacramento, California. There are other California rallies being planned, I believe next week. We'll try to elevate those on our social media. There are cuts being proposed to Medicare, which is California's Medicaid program. And if you don't find a rally, try to contact your state and local disability organizations and ask, or try to plan one on your own. Really, what we have right now is we have people power and we have the ability to file cases in court. Those are our 2 tools right now that I see. And so people power means being visible, being loud, and being together and standing up and fighting back. Thank you. I forgot, I was supposed to do this slide as well. This is still Claudia. So next week, we'll circulate a registration. We are going to be having a webinar on June 10th from 10:30 a.m. to 12 p.m. Pacific time. And we're going to teach people how to file comments on the federal register at regulations.gov. There are several anti-civil rights, Section 504 proposals being made by the Department of Energy. And we are concerned that this is a quote, trial balloon. This is sort of a first effort to start rolling back civil rights, and we want to push back hard. And then we will also have a webinar on defending Medicaid in the Senate. We haven't scheduled that one yet, but watch your emails and social media for announcements. Thank you.
Thank you so much, Claudia, and for your work in putting this together and bringing all of us to the table today to talk. I do want to leave a few minutes for some questions and answers because I'm sure many of our audience members would like to put a question forward after everything that we have presented today.
And this is Claudia. People should select English if they're an English speaker, or Spanish, of course, if they're a Spanish speaker, if we take a live question from a Spanish speaker, if you need to hear in English, and vice versa. I see a question in the chat. A number of Congress members' offices have refused to take comments from callers who are not constituents of the member's district or state. Even when the caller is contacting the office because the representative or senator sits on a specific committee considering certain bills or issues, are they allowed to refuse to register comments? Does anyone on our team want to answer that?
Hi, Julia.
So they don't have an affirmative duty to have to hear your comments if you are not a constituent. But it's sometimes an alternative option is to actually call your elected official or someone within your state, even if you're not a constituent, and just emphasize that you can even name that some people in other states and ask for them to, try to work together with that congressperson to change their mind or advocate on your behalf to that specific person. That is something effective because people in Congress are often working together in the back, on the back end. And so you can at least ask your own representative, hey, this person is advocating this way. Can you please help with informing their decision? And that can assist them. Now, sometimes you can try to get your comment pushed through for those that are not your constituents. Sometimes an email at least works because they will at least look at the email and read it. That way you aren't filtered through the phone call process.
Thank you for those two questions. I do not see any other hands up at this time, and we are currently at noon. So with any closing remarks, I'd just like to say we really appreciate all of you coming here and attending this meeting. We hope it was informative and helpful as you are making your way forward in your work or in your life for supporting people with disabilities today. We will continue to have additional webinars here at DREDF through the summer as we make our way towards the anniversary of the ADA. So please come to DREDF's website and check out our events page to keep informed. And Claudia, I'll turn this over to you for any additional closing remarks.
Thank you, everyone. We're going to just keep fighting together. Thank you for coming.